in the Court of Appeal, Criminal Division, before Lord Chief Justice of England and Wales President of the Queen's Bench Division Lord Justice Holroyd, Mr. Justice Sweeney and Mr. Justice Johnson between Regina and Wayne Couzens. Wayne Couzens, now aged 49, applies for leave to appeal against a whole life order imposed by Fulford LJ on the 30th of September 2021 at the Central Criminal Court. The application has been referred by the Registrar to the full court. We give leave. Facts. The circumstances of Couzens' crimes are notorious. He was a serving police officer in the Metropolitan Police. On the evening of the 3rd of March 2021, when the country was in lockdown because of the COVID pandemic, Couzens kidnapped Sarah Everard from the street in London. She was walking home after seeing a friend. He then transported her 80 miles, restrained in handcuffs, and took her to a remote location in Kent. There he raped and murdered her. Over the course of the next 2 days, he disposed of and burned her body. The unspeakably grim detail, as Fulford LJ was aptly to describe what happened in his sentencing remarks, can be summarized as follows. Sarah Everard was 33 when she was murdered. She was a university graduate who worked in marketing. She was described by her boyfriend as extremely intelligent, savvy and streetwise. On the 3rd of March 2021, she had spent the evening socializing with a friend who lived in the Clapham Junction area. She started walking home just after 21:00, and whilst en route, she called her boyfriend, who described her as being in good spirits, but not intoxicated. When she was near Clapham Common, she was stopped by Couzens. He handcuffed her on the pretext that she had committed some form of offence and placed her in the back of a car he had hired, as part of detailed and careful plans he had made for abducting and then raping a woman. The subsequent police investigation was to reveal what those plans were. Automatic number plate recognition, ANPR, records showed that Couzens had made reconnaissance trips to London on 23rd of January, 5 February and the 14th of February 2021. On the 10th of February 2021, he purchased a handcuff key from Amazon which was capable of being used with police-issued handcuffs. His plan was to kidnap a woman on the 3rd of March 2021. On the 28th of February he hired a car for 3 to the 4th of March 2021, because, so the judge was to find, it was more likely that he would be able to persuade his victim that a new-looking hire car was an unmarked police car than his own car, which was in a poor and neglected state. 2 minutes after he had booked the hire car, Couzens ordered a large quantity of self-adhesive carpet protector which was delivered to his home on the 1st of March 2021. Couzens was a married man with 2 young children. He also lied to his wife, saying that he would be working a night shift on the 3rd of March 2021 when in fact, he had a period of 5 rest days from 3 to the 8th of March 2021. On the 3rd of March 2021, Couzens picked up the hire car in Dover, an area he knew well. He left his own car parked nearby, out of sight of any CCTV cameras. He had his warrant card and police-issued handcuffs with him, though he was not on duty and there was no reason for him to carry them. He drove to London. At 20:00 he purchased a pack of 14 hairbands at a Tesco's store in London. These were to be used either for the purposes of restraint or to maintain an erection. Couzens then drove around southwest London for a period of at least an hour, looking for a victim. At 21:30, he stopped by Ms. Everard, who was walking along a busy main road. CCTV footage subsequently retrieved from a passing haulage vehicle showed Couzens standing on the pavement, showing Ms. Everard what appeared to be a warrant card. The hire car was visible in that footage. A lady in a passing car saw Ms. Everard, head bowed, being handcuffed, with her arms cuffed behind her back. Ms. Everard was placed in the back of the hire car and driven away. She was not seen alive again. Couzens then transported Ms. Everard back to Dover where he had parked his own car. He arrived at 23:30. He transferred Ms. Everard from the hire car to his car. He must have used physical violence or threats to do this, and drove to a remote rural location where, at midnight, he parked. It was likely that it was during the period he was there, about 45 minutes, that he raped Ms. Everard in the back of his car. Velcro straps that were subsequently found in his car are consistent with Ms. Everard being restrained at the time. As the prosecution said, it would soon have become clear to Ms. Everard that she was being kidnapped, and the ordeal that she must have suffered during that journey, and subsequently, is unimaginable. By 02:34 Couzens, still in the hire car, had driven to a petrol station where he purchased 2 bottles of still water, an apple juice, Lucozade orange and a carrier bag. It is likely that Ms. Everard had by then been murdered, as it would have been too risky for Couzens to enter that public area, had she been alive. A post-mortem examination showed that Ms. Everard was killed by pressure being applied to her neck for a period of at least 2 minutes. Couzens' own account, given only to Dr. Latham, a psychiatrist instructed by the defense for the purposes of sentence, was that he strangled her with a belt. ANPR and cell site evidence showed that after leaving the petrol station, Couzens drove to a plot of land he owned in Hodes Wood. He arrived after 03:22 on the 4th of March 2021. At some point he left the area and then returned a couple of hours later. He returned the hire car to the hire company at about 08:30, before buying some items in Costa Coffee in Dover. On the 5th of March 2021, at 23:05, Couzens purchased petrol which he used later to burn Ms. Everard's body inside an abandoned refrigerator, together with her clothing and other incriminating items. Couzens then carried Ms. Everard's heavily burned body to a nearby pond. To cover and transport her body he used 2 builder's bags that he had purchased earlier that day. On the 7th of March 2021 Couzens took his wife and children to Hodes Wood and allowed his children to play near the pond where he had disposed of her body. All the while, Ms. Everard was missing, and her family were beside themselves with worry. CCTV inquiries led to the identification of a vehicle suspected of being involved in Ms. Everard's abduction. On the 9th of March 2021, officers attended Couzens' home address in Kent. He was arrested and questioned by police using an urgent interview procedure. Couzens immediately gave the arresting officers an elaborate, but entirely fabricated account about what had happened to Ms. Everard. He claimed a Balkan criminal human trafficking gang had paid him to kidnap Ms. Everard, he had done so under duress and he had handed her over to them. Couzens had visible scratch marks to his head. He said that they were caused by his dog. Ms. Everard's remains were found on the 10th of March 2021 in 2 builder's bags in a pond. They were retrieved from the pond the following day. On the 12th of March 2021 the refrigerator used by Couzens was found by police. Ms. Everard could only be identified from dental records and examination by a forensic orthodontist. Experts concluded that Ms. Everard was not wearing her top, her coat or her leggings when her body was burned. Subsequent forensic testing found evidence of components of Couzens' DNA in vaginal swabs taken from Ms. Everard's body. Couzens' semen and Ms. Everard's blood were found in his car, as was part of Ms. Everard's SIM card. Her mobile phone itself had earlier been discarded by Couzens and was recovered by officers from the River store in Sandwich on the 18th of March 2021. Throughout the police investigation and his police interviews Couzens continued to deny his actions and maintained his fabricated account. As we have said, the only account by him was to Dr. Latham, whose report was relied on by the defense at the sentencing hearing to support a submission made in mitigation, that Couzens was suffering from underlying depression. Sentencing 68. Couzens subsequently pleaded guilty to Ms. Everard's kidnap, rape and murder at what the judge was to accept, for the purposes of sentence, was the first available opportunity. On the 8th of June 2021 Couzens pleaded guilty to kidnapping, count 1, and rape contrary to Section 11 of the Sexual Offences Act 2003, count 2. He pleaded guilty to Ms. Everard's murder, count 3, on the 9th of July 2021 at the plea and trial preparation hearing, having admitted responsibility for her killing at the hearing on the 8th of June. Prior to the sentencing hearing, the judge was given detailed sentencing notes by the prosecution and the defense and a full opening note. The sentencing hearing itself took 2 days. The judge had before him victim personal statements from Ms. Everard's family and friends. Ms. Everard's mother, her father and her sister read their statements to the court. These statements described in moving terms the profundity of their grief at the loss of a much-loved daughter, sister and friend in such terrible circumstances, and the way in which Couzens' crimes had blighted their lives forever. The prosecution submitted to the judge that this murder, and the associated offences of kidnap and rape, was of such exceptional seriousness that it justified the imposition of a whole-life order, because it was committed by a serving police constable when acting as if on duty, and because of its particular aggravating features. The defense accepted that the tariff period would be well in excess of 30 years, but submitted there had never been a whole-life term which did not come within the categories set out expressly in the relevant provisions. A whole-life tariff was an exceptional form of sentence that needed to be carefully and unambiguously justified. It was not justified in this case, having regard to mitigation provided by the defendant's guilty pleas, his remorse and his lack of previous convictions. In his sentencing remarks, the judge said he had no doubt that Couzens used his position as a police officer to coerce Ms. Everard, on a wholly false pretext, into the car that he had hired for this very purpose. It was most likely that Couzens suggested to Ms. Everard that she had breached the restrictions on movement that were being enforced during that stage of the pandemic. Any explanation other than coercion, said the judge, failed to take into account Ms. Everard's character and the evidence of the occupants of a passing vehicle who saw her being handcuffed. The judge found that Couzens had carefully planned to abduct and rape. The murder was not a definite outcome until the events unfolded, but Couzens must have realized that he may well need to commit murder. The judge said that it was clear from the language of Schedule 21 to the 2020 Act that Parliament did not intend a closed list of cases as the only cases that would merit a whole-life order. He said that the decisions of the Court of Appeal also stressed that a whole-life order is rarely made and reserved for the few exceptionally serious offences in which, after reflecting on all the features of aggravation and mitigation, the judge is satisfied that the element of just punishment and retribution requires the imposition of a whole-life order. Couzens had, said the judge, eroded the confidence that the public were entitled to have in the police. He had added to the insecurities felt, particularly by women, walking home alone at night, and he had utterly betrayed his family. His actions after the crimes were committed showed quiet and unconcerned determination to cover his tracks, and the CCTV footage of Couzens at the material time showed no hint of trauma in his demeanor. There was no genuine contrition on his part. The judge's reasons for concluding that a whole-life order should be imposed were these: I would stress, therefore, that I have adopted the approach that a judge should only pass a whole-life term in a case such as the present if he or she is confronted with a new category of exceptionally serious case that plainly calls to be treated in this way, and the decision is, therefore, not a borderline one. Otherwise, a lengthy minimum tariff period will suffice. The most important question in this sentencing exercise, therefore, revolves around a question of principle. If a police officer uses his office to kidnap, rape and murder a victim, is the seriousness of the offense exceptionally high such that it ought to be treated in the same way as the other examples set out in paragraph 2.2? In my judgment, the police are in a unique position, which is essentially different from any other public servants. They have powers of coercion and control that are in an exceptional category. In this country, it is expected that the police will act in the public interest. Indeed, the authority of the police is, to a truly significant extent, dependent on the public's consent. The power of officers to detain, arrest, and otherwise control important aspects of our lives is only effective because of the critical trust that we repose in the constabulary, that they will act lawfully and in the best interests of society. If that is undermined, one of the enduring safeguards of law and order in this country is inevitably jeopardized. In my judgment, the misuse of a police officer's role, such as occurred in this case, in order to kidnap, rape and murder a lone victim is of equal seriousness as a murder carried out for the purpose of advancing a political, religious, racial or ideological cause. All of these situations attack different aspects of the fundamental underpinnings of our democratic way of life. It is this vital factor which, in my view, makes the seriousness of this case exceptionally high. Self-evidently, it would need for the police officer to have used his role as a constable in a critical way to facilitate the commission of the offense. If his professional occupation was of little or no relevance to the offending, then these considerations clearly would not apply. Added to this, the aggravating features in this case are extensive. As I have already rehearsed, there was significant planning and premeditation. The victim was abducted. There was the most serious sexual conduct. The defendant was responsible for significant mental and physical suffering, which he inflicted on the victim before her death. And the defendant concealed and attempted to destroy Sarah Everard's body. There is no doubt but that these three offences are inextricably linked and, in considering the correct sentence for murder, I have taken into account the kidnapping and the rape in order to pass a single sentence. I have borne in mind the fact that the defendant pleaded guilty in deciding whether it is appropriate to make a whole life order. This has saved the Everard family and Sarah Everard's friends from enduring a trial. That said, having determined, as I have, that there should be a whole life order, given the misuse of the defendant's role as a police officer and the serious aggravating features, self-evidently there can be no reduction for the defendant's guilty pleas. Submissions. Mr. Sturman QC, who appears for Couzens as he did below, accepts on his behalf that the crimes were abhorrent, and emphasizes that nothing is intended to minimize this, or the effect of Ms. Everard's murder on her family and wide circle of friends. However, he submits that despite the unprecedented publicity which the case attracted, this was not an exceptional case within the meaning of Schedule 21 which merits a whole life order, given that it involved the killing of one person. Whilst Mr. Sturman accepts the categories of exceptionality are non-exhaustive and not closed, he points out that this case is unique amongst the whole life orders that have been imposed, in not falling into one of the Schedule 21 paragraph 2 categories. Further, he submits that the finding that there was no remorse is untenable in circumstances where Couzens did not continue with the false account he gave to the police on his arrest but pleaded guilty before much of the evidence was served. He accepts Couzens deserves many decades in jail but submits the mitigating combination of Couzens' remorse and guilty pleas should have balanced out the aggravating factor that he was a serving police officer. Mr. Little for the Crown, who also appeared below, submits the whole life order was not wrong in principle or manifestly excessive. Specifically, there is nothing to support the contention that it is wrong in principle to regard this offending as of the utmost seriousness because the offences were committed by a serving police officer, using his know-how to perpetrate the offences. Police officers are in a uniquely powerful position, as the facts of this case demonstrate, with Ms. Everard's detention and kidnap mid-evening on a very busy road. There is, Mr. Little says, nothing in the sentencing remarks to support an argument that the judge misapplied the statutory provisions or failed to take account of the relevant case law. In respect of the categories identified in Schedule 21, he submits it is not surprising that Parliament failed to legislate for a case of this nature, which is so unforeseeable. This is, therefore, a rare height case. The judge's sentencing remarks were clear, coherent and comprehensive, and involved a proper exercise of judgment and application to the facts. For the reasons given by the judge, this was a truly exceptional case meriting a whole life order. Discussion. We deal first with remorse. The judge assessed whether Couzens was truly remorseful. We do not accept that his conclusion on that issue can be impugned. Remorse is different from acceptance of guilt. Couzens' guilty pleas were a mitigating factor. But in gauging whether his contrition was genuine, it was relevant that at no stage had Couzens offered a full explanation for what had occurred. Instead, he had sought to minimize his true responsibility from the moment he had first spoken to the police when he lied about the people trafficking gang, to the revealing, and wholly implausible account, in fact, the only account given by Couzens, to Dr. Latham. The examples of this given by the judge were telling. They showed that Couzens had sought to minimize his responsibility for the cold-blooded and calculated planning that had taken place prior to the kidnap, rape and murder, and the chilling and methodical attempts thereafter to cover up his crimes, and that he had thus sought to minimize the true horror of what he had done. In his account to Dr. Latham, for example, Couzens suggested he had rented a car because he had problems with his own vehicle. As the judge put it, his explanation could not survive the sequence of events prior to his departure for London and after his return with Ms. Everard. The true position was that Couzens wished to use a car that was credible as a police vehicle and wanted to avoid his own car being identified as having been in the relevant area when he kidnapped his victim. Couzens also claimed to have driven around London on the 3rd of March 2021 in a state of confusion. As the judge pointed out, this was entirely at odds with the precise and careful steps Couzens had taken before committing these offences, and with the lengths to which he went to avoid detection, which included lying to his family and purchasing items such as the carpet protector. This supposed vague state of mind was also contradicted by Couzens' calculated behavior over the entire period, including buying food and drink, organizing family-related appointments, and coolly taking his family on an outing very close to where he had left Ms. Everard's body. It is notable too that many important features of what had happened were never described by Couzens but had to be pieced together by the outstanding police investigation that took place after Ms. Everard was kidnapped. The issue at the heart of the appeal is whether this murder, with its unique features, justified the judge's overall conclusion that it merited a whole life order. We have concluded that it does, albeit we would, with respect, arrive at this conclusion by a different route from the judge. The circumstances of this case were not within the categories in paragraphs 22a2e of Schedule 21, i.e. cases which would normally be of exceptionally high seriousness, see para. 9, above. As a single murder involving sexual conduct, this case fell at first sight within one of the categories of cases, paragraph 32e of Schedule 21, which would normally be of particularly high seriousness, with a starting point of a minimum term of 30 years. As the observations of Lord Judge C.J. in Height make clear, see para. 19x, above, the seriousness of an offence may be regarded as exceptionally high even though the circumstances of the case do not fall within one of the criteria set out in paragraph 22 of Schedule 21, because those criteria are not exhaustive. It is for that reason that in some cases, probably rare, the seriousness may be such as to justify the exceptionally high starting point, even when the express criteria normally required for this purpose are absent. It is thus open to a sentencing judge, albeit rarely, to conclude that even though the circumstances of the case do not fall within the paragraph 22 criteria, the seriousness of the offence to be sentenced is exceptionally high and therefore a whole life order is justified on the facts. Fulford L.J. was careful to identify all the facts which led him to conclude that a whole life order was appropriate in this case. But in the opening paragraph of the quotation from his sentencing remarks which we have set out, he spoke also of identifying a new category of offending and a point of principle whether a police officer using his office to kidnap, rape and murder a victim should fall within paragraph 22 of Schedule 21. In our view, the correct approach is to focus on the facts which in a rare case might lead to the conclusion that a whole life order is appropriate rather than to create a new category. That would be a matter for Parliament. A careful application of the relevant principles described above provides scope within the statutory scheme for an appropriate sentence by reference to the particular facts of each case. Those principles establish that each case will depend on its particular facts. Schedule 21 must be applied in a flexible and not rigid way to achieve a just result. As we have said, it is the application of the principles to a careful assessment of the relevant facts of the case that is important. The statutory scheme provides that whether the starting point is a whole life order or a minimum term, the aggravating and mitigating factors that the court must consider may result in a departure from the starting point. If the starting point is a whole life order, then the balance of mitigating factors and aggravating factors might result in the imposition of a minimum term order. Conversely, if the starting point is a minimum term order, then the balance of aggravating factors and mitigating factors might result in the imposition of a whole term order. This was, as the judge said, warped, selfish and brutal offending, which was both sexual and homicidal. It was a case with unique and extreme aggravating features. Chief amongst these, as the judge correctly identified, was the grotesque misuse by Couzens of his position as a police officer, with all that connoted, to facilitate Miss Everard's kidnap, rape and murder. We agree with the observations of the judge about the unique position of the police, the critical importance of their role and the critical trust that the public repose in them. In our view, the starting point for this case, a single murder involving sexual conduct, was a minimum term of 30 years under paragraph 32E of Schedule 21, but having regard to its aggravating features, we are in no doubt that its seriousness is so exceptionally high such that a whole life order rather than a minimum term order should be made. We consider this to be the correct route to a just result in this case. It provides for its unique and defining feature, which was that Couzens had used his knowledge and status as a police officer to perpetrate his appalling crimes against Ms. Everard, and for the extensive and extreme nature of the other aggravating features which were present, the significant and cold-blooded planning and premeditation, the abduction of Ms. Everard, the most serious sexual conduct, the mental and physical suffering inflicted on Ms. Everard before her death, and the concealment and attempts to destroy Ms. Everard's body. We agree with the judge that having determined there should be a whole life order, given the misuse of Couzens' role as a police officer and the serious aggravating features of the offending, the guilty pleas did not affect the outcome. It follows that Couzens' appeal is dismissed. Please like, comment and subscribe for further court updates.